Well, good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, Estate Planning for the Surviving Spouse, Considerations, Recommendations, and Procedures, with our presenter, Elville and Associates Senior Principal and Estate Planning Team Leader, Olivia Holcombe-Volke. So briefly, if you haven't joined us before, if so, welcome. We're glad you're here. The way this will work today is you as the attendee are in listen-only mode. However, there is a questions panel on your screen where you can ask questions and interact with me throughout the presentation, and we'll pause to field those questions throughout the presentation as well as at the end. You received the presentation for today from me by email yesterday. However, if you did not receive the presentation for some reason, it is currently located in the handouts section in your panel on your screen to download at this time if you want to take notes on it. Also, for certified financial planners, CPAs, and other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So if I do not have it already for my records and reporting requirements, please email me your board ID. And also for CFPs only, I need the last 4 digits of your social security number as soon as possible. And I'll also be sending out CPA CE certificates soon after the webinar. Everyone will also receive a post-webinar feedback email right after the presentation. And we do ask that you please take just a couple of minutes to fill out this simple survey to offer us your feedback about the presentation. You can also share some ideas about presentations you'd like to see us offer. And it's also a great opportunity to request a time for a consultation with Olivia to discuss your planning needs that you may have now or in the near future. And we always look forward to being a resource for you here at Elville & Associates, and there is nobody better to guide you through your planning than Olivia. So briefly, I'd like to share some information about our firm as well as Olivia before we get started. So Elville & Associates, I've been here for 8 years, and Olivia is a veteran of the firm as well. We were founded in 2010 in Columbia by managing principal and lead attorney Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business and succession planning, asset protection, guardianship and litigation, and tax planning. We have 7 attorneys, 12 staff members, and 5 locations. And we're coming to you from the Columbia location, which is our primary location in the Columbia Gateway community. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at the firm, and that separates us from a lot of the other firms that are out there. We do that through our planning processes with our clients. We do offer over 100 educational workshops and webinars in the communities we serve each year, covering a wide array of different topics. And also by way of our accredited client care program, we're only one of 2 law firms in the state of Maryland to be accredited by the Client Care Academy in Boston. So that is a program that has a lot of different benefits that many of our clients take advantage of. And if you have any questions about that, you can ask me, and I'll be happy to share some more information about the CCP, as we call it, with you. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every time. A little bit about Olivia. Olivia is our senior principal and senior estate planning attorney with Elville & Associates, and her work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. She is a seasoned speaker and presents at numerous workshops, conferences, and continuing education events each year. She was named to the Maryland Rising Stars list by Maryland Super Lawyers in 2017, and also named 10 Best for Client Satisfaction in Estate Planning by the American Institute of Legal Counsel in 2018 and 19. And as always, we're very proud of the volunteer work that Olivia offers in the communities that we serve. She is a board member for the Women's Law Center of Maryland, is the chair of the Judicial Selections Committee for the Women's Law Center of Maryland, and also a volunteer attorney for the Maryland Volunteer Lawyers Service, the MVLS. She's also a founding member of the MVLS Community Advocacy Network, and also was the Volunteer of the Month for May 2019 for the MVLS. She also provides training to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So Olivia is very busy, and we are very pleased to have her here today to share her knowledge on estate planning for the surviving spouse. So lastly, before we get started, I'm going to jump into a poll to see what has brought you here today. And if I can find that poll, I'm going to launch it. There it is. Okay. So the poll is, as an attendee of today's webinar, what is your main purpose for seeking education today? And your choices are, I can find it, here it is. So again, as an attendee of today's webinar, what is your main purpose for seeking education today? And the choices are, I am currently a surviving spouse looking for guidance. Secondly, I am seeking knowledge for the future. Thirdly, I have a friend in need that is a surviving spouse. Or lastly, I'm an advisor seeking knowledge to better serve my clients. So if you can just take a moment to select the choice that best represents why you're here today, gives us an idea of who we have with us today. And we'll take another 10 seconds or so. All right, looks like we have about 3/4 of people having cast their thoughts. So it looks like we have 12% saying, I am currently a surviving spouse looking for guidance. 50% saying, I'm seeking knowledge for the future. Nobody saying they have a friend in need that is a surviving spouse. And 39% saying, I'm an advisor seeking knowledge to better serve my clients. So welcome to all. And I'm going to now turn the controls over to the very capable hands of our presenter, Olivia Holcombe-Volke. Olivia, you should see the button pop up giving you control of the screen.
Excellent. Thank you, Jeff.
Okay, my pleasure.
All right, let's see. Is it sharing my screen?
Yep, there it is.
All right. Well, good morning, everyone, and thank you, as always, for that introduction, Jeff. So hopefully everyone received the email that Jeff sent with my PowerPoint slides, and from that, you will see that I've actually organized my presentation today such that I'll be spending the first part of the presentation focusing on the specific subject matter of thinking in terms of estate planning considerations when we're talking about a surviving spouse. The latter part of my presentation today is where I will take the opportunity to actually do a fairly brief review of fundamental estate planning concepts and documents. So if you have been a part of any of the presentations that I've given in the past, or in terms of any estate planning presentations specifically about fundamental estate planning documents, you'll recognize the latter part of the presentation, and you may not need to watch it again. But the reason that I do that is because I always think it's useful to just refresh everyone's recollection or help bring people to an understanding of what the fundamental estate planning documents are and the purposes that they serve. But the starting point of my presentation today will be to really focus on what some of the planning considerations are when we're talking about a surviving spouse. And I'll tell you, the reason that I thought that this would be a good topic to present on is simply because of the number of clients with whom I've worked where I've discovered that there are certain elements that are relevant to estate planning between a married couple, or when there is a surviving spouse after the death of the prior spouse. There are elements to it that I have found many people are unaware of that I think are important elements to educate all of you on, just so that you have that awareness. I joke about the fact that as an attorney, it's my job to bring things to your list of worries that you didn't know you needed to worry about. But all joking aside, the real purpose of this is simply so that you can make the most informed decision. And the only way that you would be able to do that is to know all of the factors that need to be taken into account. So let's get started. When we are talking about the term surviving spouse, what that inherently implies is that there were once two individuals involved. So two spouses involved in the accrual of the estate assets, and two individuals involved in the discussion and contemplation regarding what should happen with those assets after death. So there will be two perspectives to this discussion. One angle is to think about these things in terms of if we're dealing with a married couple where both spouses are currently living. And another aspect or perspective is to think in terms of a surviving spouse after their spouse has already passed away. The specific considerations that I'm going to focus on revolve around remarriage, asset protection, and tax planning. Now, these three considerations have areas where they overlap, and often the planning tools that we have that you can choose between, there are often ramifications with those tools that are relevant to remarriage and asset protection and tax planning. So there's a lot of overlap between these considerations, but there are also areas in which they are distinct from each other. So let's talk first about remarriage. This is almost always one of my favorite parts of the conversation that I might have with clients, simply because frequently what happens is that either the married couple with whom I'm working laugh and look at each other and swear never again, or one of them says to the other, "I will haunt you." Or if I am dealing with or working with a current surviving spouse whose spouse has passed away, especially if time has gone by such that they're past the point of the grief, then they often say, "Oh no, I would never do that again." Well, even with those commitments to never again, or knowing that you would be haunted if you were to get remarried, let's recognize the reality that many people do get remarried. And in fact, if you are part of a second or third marriage, and that is the current marriage that you are part of, and perhaps there's a blended family element where there are children from prior relationships, or you and your spouse have different intentions about what you want to happen at death, these are relevant considerations to take into account in all of those circumstances. So let's start first with something that I find almost everyone is unaware of, and that is something called the elective share. What that refers to, under Maryland law, and I'm a Maryland attorney and a District of Columbia attorney, I can't speak to all of the other state laws, but I can say that in general, this is applicable across the board. And the reason behind it, I will explain. What this refers to is the fact that a surviving spouse has rights to part of the estate of the deceased spouse, regardless of whether the deceased spouse wrote a will or a trust, leaving their assets elsewhere. So regardless of what the will or the trust may say, if the deceased spouse disinherited the surviving spouse by not leaving them anything, or by not leaving them a sufficient amount to equal the elective share, the surviving spouse can actually overrule and override the documents of the deceased spouse and elect to receive the share of the deceased spouse's estate that they are entitled to under the law. Now, the reason behind this, because of course people's reaction is typically, well, that doesn't seem fair. The reason behind it is actually a public policy reason. It was originally when one spouse, frequently the male, worked outside of the home and earned the majority of the assets, and the other spouse, again in the past, a female, was typically in the home raising the children. And so the reasoning behind the elective share law was to ensure that the husband would not be able to disinherit the wife such that the wife would then be reliant on government benefits. This is the origin of the elective share law. It persists today, and it is applicable such that if your intention is to disinherit your spouse or to leave less than the percentage they are entitled to, you need to be aware that at your death, they could assert their rights to the elective share of what they're entitled to from your estate. So, even when clients who are a married couple and they come to me and they say, we both agree, he's going to leave his money here, I'm going to leave my money here, and we agree, we don't disagree about that. The elective share could be asserted by the power of attorney or legal guardian. So if the surviving spouse has lost their mental capacity after the death of the first spouse, the reality is the power of attorney or legal guardian of the surviving spouse who's now incapacitated could assert the right to the elective share on their behalf. And guess what? Frequently, the power of attorney of the surviving spouse is their child, their adult child. So it can be very complicated. And even when we think that we have an understanding between each other and nothing's going to violate that agreement, there are elements that are relevant based upon what the law says. We have to take these things into account. So where does that lead us? Well, now let's talk about the element of pre- and post-nuptial agreements. First of all, let me say what I'm going to talk about with pre- and post-nuptial agreements is not relevant to divorce. I am not a divorce attorney, thank goodness. So my comments on pre- and post-nuptial agreements come from the perspective of estate planning. And what the relevance is this. Part of what can be covered in a pre or a post-nuptial agreement is the contractual agreement between the spouses that they will each be entitled to direct their estate at death to whomever they choose, and the other spouse will not be able to override that. So it's a contractual agreement where each spouse basically says, you can leave your estate where you want to, and I won't take any action after your death to override that. And I can leave my estate to anyone I want to, and you won't take actions after my death to override that. It doesn't mean that I can't leave my estate to you. I can, but if I choose not to, you do not have the right to override what I've done. So pre- and post-nuptial agreements help accomplish that. And so if you are part of a marriage currently where you have different planning intentions from your spouse, even if you both agree to those different intentions, I always recommend that clients contemplate how important is it to you to have as much certainty as possible that your agreed upon plan to each leave your estate differently. How important is it to you to have certainty that that will succeed? And if it's important enough to you to have certainty, then I recommend that you implement a post-nuptial agreement. For everyone who is contemplating marriage, a prenuptial agreement is a good way to go into the marriage knowing that you've separately agreed to be able to do whatever it is that you wish with your separate assets. So if you are a surviving spouse now, and if at any point you do plan to get remarried, and if it's important to you to make sure that you can still control where your money will go at your death, and that it won't have to go to your new spouse, or that they won't have the right to direct that or enforce that, sign a prenuptial agreement before you get remarried. So the next planning strategy that's available when we're talking about considerations regarding remarriage, and when I'm talking with a married couple and they do have concerns about the risk of remarriage, primarily, I don't want my money to end up in the hands of some person who wasn't part of this family, who didn't earn the money. I want to make sure that the money I worked hard to earn, certainly I want it to benefit my surviving spouse as long as he or she is living. But when he or she passes away, I want it to go to my children or to my nieces and nephews or to our children, not to some new spouse and their family. So this is where one of the strategies that we have available is to incorporate planning into the estate plan, where at the death of one spouse, that spouse's assets will go into some type of irrevocable trust that will be for the benefit of the surviving spouse as long as they are alive. But they will not own those assets, which means that those assets will not be under their control to direct to some new spouse or other people at their own death, and it won't be eligible for a new spouse to assert the elective share against it, because that irrevocable trust is not considered the estate of the surviving spouse. So irrevocable trusts are one of the really effective, really good tools that we have whenever clients are concerned about the remarriage risks. Planning for irrevocable trusts to hold the inheritance at the death of the first spouse is something that we really need to talk about. And there's several different types of trusts that are available, and on the next screen I'll talk more about those. One of the other choices when people are concerned about what if I die first and my surviving spouse gets remarried and then they do something different with the estate than what we had agreed to, or their new spouse does assert the elective share. So one of the other planning strategies is to talk about whether the current married couple would like to plan in some way such that at the death of one of them, there is immediately money or assets that will skip the surviving spouse and immediately go to the children or to the nieces and nephews or to whomever it is that the intended ultimate beneficiaries are. Now, when we're talking about skipping the surviving spouse, obviously one of the considerations that we have to take into account is making sure that the surviving spouse will have enough assets for what they may need for the remainder of their life. So we don't want to skip the surviving spouse to such an extent that we impoverish them, at least most clients don't. And another element of skipping the surviving spouse that we have to take into account is the surviving spouse's right to the elective share. So talking about planning in such a way that perhaps you avoid the worry of your surviving spouse getting remarried by simply saying, at my death, regardless of if my spouse survives, I want immediately for certain assets or a certain percentage to go ahead and go to my children or whomever I want my beneficiaries to be. Talking about that as a way to say, and then the rest can go to my surviving spouse, and I'm just not going to worry about it. If they get remarried, if they do something else with the money, I'm not going to worry about it because at least I've gone ahead and gotten some of my estate to the people that I want to ultimately receive it. So that's one method, but as I say, it involves, we have to take into account various considerations with that. Jeff, any questions so far?
Thanks, Olivia. No questions as of right now.
Okay.
So you can continue. Thank you.
All right. So now to talk about the second consideration when we're talking about planning for a surviving spouse. And this is asset protection is the main consideration here. But with this, part of what I will talk about are the different types of trusts, irrevocable trusts, that we can implement as part of the plan such that at the death of one spouse, the assets of that deceased spouse would then go into an irrevocable trust for the benefit of the surviving spouse. So these trusts are partially used sometimes to deal with remarriage concerns, but these are also relevant considerations and planning tools when people are motivated to think about asset protection for the surviving spouse. And this is something that I also will say, if you actually are the surviving spouse. Frequently, I find that clients have lost their spouse and come in to see us and don't understand the purpose behind why the deceased spouse's estate plan set things up such that they would flow into an irrevocable trust. Many times people don't remember the conversation as to why this was structured this way, or don't fully understand why it was structured this way. And part of it actually is a benefit to the surviving spouse. So it serves a benefit for the deceased spouse to structure things this way to protect against remarriage concerns, for example, or sometimes to protect against the concern that the surviving spouse may not be the best at managing money or may not have full mental capacity to handle managing money. So for those reasons, the irrevocable trusts benefit the deceased spouse, and that was part of their intention. But they also serve the purpose of benefiting the surviving spouse. And so often when I work with clients who don't understand and perhaps don't want their deceased spouse's estate to actually go into the irrevocable trust plan that was set forth by the deceased spouse, part of what I always try to emphasize is there is actually a benefit to you as well. And that comes in the form of asset protection. So there are several different types of trusts that are relevant. And then I also will talk a bit about the retirement asset aspect of this in terms of inheriting 401k or IRA or TSP assets from a deceased spouse. So with asset protection and irrevocable trusts, there are several different options. One option is what is known as a marital trust or a Q-tip trust. So those terms that people may hear refer to a type of trust where the surviving spouse is the only beneficiary. A different type of irrevocable trust that is used sometimes to plan for what will hold the deceased spouse's estate for the benefit of the surviving spouse for the purpose of remarriage protection and asset protection is known as a bypass or credit shelter trust. And this type of irrevocable trust allows the surviving spouse and perhaps others to be beneficiaries. And this can be relevant in terms of thinking about who the allowable beneficiaries are. This can be a relevant concern if we're planning for a married couple where there are still young children. And so we would want to make sure, potentially, that those young children could also be beneficiaries of the bypass or credit shelter trust. So those are two types of irrevocable trusts that provide some remarriage protection and some asset protection. Now, the differences between the two, in addition to the consideration about who can be the beneficiary or beneficiaries, another element that's important for clients to take into account is who can be the trustee. And that's a choice that the clients get to make at the time that they write the plan. And when we're talking about who the appropriate trustee is, the conversation that I always have with people is, I want you to think about this in terms of, if the surviving spouse is the trustee, then that will serve the benefit of the surviving spouse not having to ask for money from this trust from some other person and not being beholden to some other person to be able to get money out of this trust. But of course, the reverse of that is that it also means that if the surviving spouse is the trustee, they will be able to make decisions and do pretty much what they may want with the assets in the trust, because they won't be asking permission or seeking approval or consent from someone else. So that's a part of the conversation and the consideration. With that, when people are extremely concerned about the remarriage protection, frequently what they decide to do is to either have someone other than the surviving spouse act as the trustee, or have the surviving spouse and someone else act as co-trustees, because they feel that provides some extra security that the surviving spouse won't be able to carte blanche empty the irrevocable trust and then give it to a new spouse. So that's part of the conversation. But if people are primarily focused on the asset protection aspect of this, then often they do decide, I just want my surviving spouse to have asset protection, but I don't want to restrict or limit their ability to access the money and do what they need to with it or what they want to with it. Another element of the distinction between the marital or Q-tip trust and the bypass or credit shelter trust, not only is it who can be the beneficiaries, there is also a distinction between the two with regard to distributions of money from the trust. The marital or Q-tip trust has a mandatory requirement that all income earned on the trust assets must be distributed annually to the surviving spouse. Whereas the bypass or credit shelter trust does not have that requirement. Another distinction between them is that with a Q-tip trust, we cannot build in any language that says anything along the lines of, if the surviving spouse gets remarried without signing a prenuptial agreement, they lose all rights to the money in this Q-tip trust. We cannot do that. We cannot put those prohibitions on remarriage in a Q-tip trust. But we can put those prohibitions on remarriage in a bypass or credit shelter trust, specifically saying if the surviving spouse gets remarried and does not sign a prenup, they lose their rights to the bypass trust, and it basically terminates and goes ahead and distributes on to the next beneficiaries in line, the children or the nieces and nephews or whomever that may be. So those are some distinctions between them, and those are always part of the conversation as to which type of trust is appropriate. One further thing that I will add to this, and this is something I will talk about more on the next slide, but there are tax differences between these two as well. And basically, under current law, and I'm sure everyone is very aware, the law changes all the time, and currently we are on the precipice of some potentially large changes to the particularly estate and gift tax and capital gain step up in basis regimes in the federal government under the Internal Revenue Code. All of that is currently in the works to change. But all that we can do right now is plan based upon what we know right now. And so under current law, the tax differences between these two trusts in terms of what's relevant to estate planning is that the Q-tip trust is included in the surviving spouse's estate for the sake of calculating the surviving spouse's estate tax exposure. But the benefit of that is that the assets in the Q-tip trust got a step up in tax basis for capital gain purposes at the death of the first spouse, and they get a second step up in basis for capital gain purposes at the death of the surviving spouse. This is a major benefit. The bypass trust does not have that same benefit. The bypass trust is treated as part of the deceased spouse's estate, and it does get a step up in basis at the time of funding, which is when the first spouse dies, but then it does not get a second step up in basis at the death of the surviving spouse. So this is a lot to remember, and my point in sharing all of these nuances with you is to explain that there are different factors that have to be taken into account to determine which grouping of factors are the most in line with a client's intentions, and to therefore help make sure the plan is written in such a way that that's what will take place. And I will further say there are also plans where someone may do a hybrid of these two types of trusts. There are some circumstances where that's the appropriate way to plan. But on the side of the surviving spouse who says, well, I don't understand why my deceased spouse wrote their will or trust to leave their estate into some irrevocable trust for my benefit, it's often best. We don't recommend that clients choose to disregard that in any way. That is a plan that was put into place in order to accomplish certain benefits, and so that should be followed. The next thing that I'll talk about with regard to asset protection is thinking about when there's a married couple where one spouse is not well and the other spouse is healthy and is concerned about if they die first and leave all of the assets to the surviving spouse. If the surviving spouse has skilled nursing needs or is unable to work and needs to rely on government assistance because of that, there is the concern that if all of the assets go to the surviving spouse, that all of the assets will then end up being used for the surviving spouse's medical needs and to basically cover everything that they need because they cannot earn an income. So when we're talking about that situation, one of the planning options that's available is to plan for, at the death of the healthy spouse, having the assets go into what's called a supplemental needs trust. And this is a type of trust where it's for the benefit of the surviving spouse, but they cannot be the trustee, and they do not have any rights to make demands on money coming out of the trust. But the benefit of it is that the money in the supplemental needs trust is not treated as available to the surviving spouse, so that the surviving spouse can be eligible for Medicaid and SSI and potential other government benefits and government assistance that are partially contingent upon how much money or what available assets the applicant has. The last thing that I'll talk about on this screen is in terms of retirement assets. Again, 401k, TSP, IRA. These are very specific animals in terms of income tax treatment. And so when we have retirement assets and we're planning for the surviving spouse, one of the things that we have to talk about is, if your motivation is to accomplish as much remarriage protection and asset protection as possible, then you may be motivated to leave your retirement assets to a trust for the benefit of your surviving spouse. But what you need to know is that the trade-off in doing that is that your surviving spouse will have less favorable income tax results with that inherited retirement asset. Whereas if you leave that inherited retirement asset outright to the surviving spouse, one of the choices that the surviving spouse has is to roll over that inherited asset, and so that it actually becomes treated as their own retirement account, and they have all of the income tax benefits that the original owner had in terms of the calculation of the required minimum distributions. So the conversation with retirement assets, whenever I'm talking with married couples who do have concerns, especially about remarriage, and they want to make sure there's an irrevocable trust that will come into existence for the benefit of the surviving spouse, we have to have the conversation about, is it your intention to do that even with the retirement accounts, even knowing that that will result in a less favorable income tax treatment on those assets? There is no way to have our cake and eat it too. I wish that there was. I keep looking for that answer, but there isn't. And so everyone just has to know what the different considerations are and determine which combination of factors work the best for their intentions and their assets. I'll pause again. Jeff, any questions?
We have a contemplated group, Olivia, so no questions right now. I do encourage anyone who does have questions, please go ahead and pose them. Very happy to answer them, and know you've got some questions in your head out there.
Thank you.
Okay, thank you.
So the third consideration when we're talking about planning and a married couple and planning for a surviving spouse is with regard to tax planning. And so with this, of course, everyone agrees that I don't know of anyone that I've ever spoken to who is not interested in having the conversation about minimizing or avoiding taxes. And so this has to be a part of the conversation too, specifically in terms of what are the taxes that are really relevant when we're talking about estate planning, and specifically within the context of estate planning between a married couple. Estate tax is obviously one of the most relevant, and estate tax is something where the relevant application of this is what is the current law in the state where you reside and at the federal level with regard to how much money is an individual allowed to have in their estate at death. And here I don't just mean liquid cash, it takes into account all assets. How much is someone allowed to die with without facing estate tax? And that's called the estate tax exemption. In Maryland currently, that's $5 million per person. Federally, currently, that's $11.7 million per person. Between spouses, you can actually share those exemptions. That's something called portability. It does require actually filing a necessary tax return after the death of one spouse in order to notify the taxing authorities of the intention of the surviving spouse to take the exemption from their now deceased spouse, meaning the exemption that their now deceased spouse had and did not use. So their surviving spouse's intention to port that remaining exemption over and add it to the surviving spouse's own exemption, that's called portability. It requires filing a necessary tax return to elect portability. That is something that I will say not only to married couples for the sake of them understanding that that's one action item after the death of one spouse we need to look into and determine, do we need to do the necessary portability election? But that's also an important point for a surviving spouse. Now, if too much time has gone by, that's a lost election. But if you are a surviving spouse whose spouse has died recently in the last 9 months, it's a worthwhile thing to talk about to determine should you file the portability election. So the estate tax is a tax that is relevant if the amount of assets in your estate exceed the estate tax exemption that's available at that point in time. I mentioned the current exemptions, but I also previously mentioned we are currently in the middle of some major possible changes to that particular estate tax exemption at the federal level. So through Elville and Associates and the news in general, I know most people are paying close attention to that and keeping tabs on what may end up ultimately happening. So the estate tax is a relevant tax to talk about in terms of the size of a married couple's estate. the other factors that matter to them, such as the remarriage protections and the asset protection element. Because if estate tax is a relevant concern, or if people are even just kind of towing the line or anywhere close to the line of it being a concern, then we have to talk about how to take into account remarriage protections, how to take into account asset protection considerations, while also taking into account how does estate tax come into this in terms of how the assets are treated, either as the estate of the deceased spouse or as all flowing over into the estate of the surviving spouse, where all of the assets will now be treated as part of the surviving spouse's estate. So we may want to make sure that we also port the deceased spouse's unused estate tax exemption so that the surviving spouse not only has all of the assets treated as part of their own estate, but also has the benefit of both their and their deceased spouse's estate tax exemption amount. Because a piece of this that's relevant is that there is something called the marital deduction, which means that you can actually leave an unlimited amount of money to your surviving spouse, and there is no estate tax at your death. But then all of that is treated as part of your surviving spouse's estate. And that's where we have to pay attention to whether they are going to exceed the available estate tax exemption. So complicated things to think about, but just another factor in the puzzle that we have to build appropriately based upon your particular goals, your particular concerns, and your particular assets, and of course, your family makeup and the current tax laws. Another consideration is income tax. And here, I mentioned it briefly with regard to a relevant consideration in terms of inheriting retirement assets and the different strategies that we have for how a surviving spouse may inherit retirement assets and what the income tax considerations are on those different methods of inheriting that type of asset. It's also relevant, as I mentioned, with regard to the capital gain step up in basis treatment of utilizing either a marital Q-tip trust or a bypass credit shelter trust. Those types of irrevocable trusts serve various purposes, but they also have different treatment in terms of capital gain and step up in basis, which are income tax considerations. Leaving assets outright to a surviving spouse will also give the surviving spouse those assets with a step up in basis. And then at the surviving spouse's death, a second step up in basis for the next beneficiaries. So really talking about capital gain and income tax, it's most relevant when we're contemplating utilizing some form of irrevocable trust because we want to accomplish asset protection and remarriage protection. So those are the tax planning conversations that are really relevant to thinking about estate planning for the surviving spouse. And then once a spouse is surviving, thinking about, do certain tax elections need to be made, and do certain actions need to be taken with regard to the step up in basis. And that leads to my last slide on this particular topic, which is if you are a surviving spouse, I highly encourage you to review the plan, revisit and update the plan, make sure that whatever the plan was, such that however it was supposed to happen at the death of your spouse, that that's actually followed and carried out properly, particularly for tax considerations. So as a surviving spouse, review the plan, don't ignore it, revisit it, update it as necessary, and remember that if you are going to get remarried, a prenup is a good idea just to make sure that you continue to protect your right to plan for your estate however you may choose. So that's it for this part of the presentation, and then I will shift gears to my review of just the fundamentals of estate planning and what that means and what the relevant documents really are. But again, Jeff, I'll pause for one moment.
Yes, thank you, Olivia. I do have a question that's related to portability, so it's a good time to address that. Thank you. So the question is, what is the current status of the carryover of unused exemption portability after the death of the first spouse? What might happen to this carryover under proposed tax law changes? And then the question does cut off, but I hope you get the understanding of what he's trying to say.
I do, thank you. And the answer to that is I will have to get back to you. I do know that Steve did an excellent presentation on all of the detailed nuances of the various tax plans that are being proposed. So there are several different senators and then of course the president that are all proposing various changes to the tax plan in terms of carryover basis, estate tax exemption, capital gains, step up, all of that. So the most concise and kind of synthesized answer to that question is one that I will have to get back to this person on. So if you'll please note who that is, Jeff, we'll get them an answer.
I will.
Okay. Anything else for the moment?
Not at this time. Thank you.
Okay. All right, well, so as I mentioned, I think it's always helpful to just do a brief review of estate planning because it does turn out that it's something that many people don't have a very clear understanding of what it really means. So estate planning often is thought of as what happens when I die? Where does my stuff go and who handles it? But that's actually not all that it's relevant to. Estate planning also incorporates planning for what will happen with your health and medical and physical well-being if you are still living but incapacitated. And what happens with your property and your assets and your money if you are still alive but you become incapacitated. So estate planning covers not only what happens with my stuff when I die and how and who handles that, but also what happens with me and my health and physical well-being and property if I'm still living, but unable to manage for myself. So incapacity planning, what it really means is avoiding guardianship. And here again, I find many people are not familiar with what I'm talking about when I mention this. The bad news is, if an adult loses their mental ability from an accident, from an illness, from random life circumstance, we have no way of predicting what's going to happen when. If an adult loses their mental ability and they never signed legal documents giving another adult the ability to act on their behalf with healthcare decisions and with regard to their money and property. Unfortunately, what has to take place is that the court gets involved and appoints a court-appointed guardian to manage that incapacitated adult's health and to manage that incapacitated adult's money. No one likes the idea of having potentially a stranger appointed as their guardian, and no one likes the idea of having the court basically supervise decisions that are being made with regard to their health and their money. So when we talk about incapacity planning, what we're really talking about is avoiding guardianship. And we accomplish that with several different documents. The first deals with healthcare. In Maryland, this is called an advance medical directive. In some states, it's referred to as a healthcare power of attorney. The purpose of it is to give you the ability to designate an agent, which is the person you are giving permission to make decisions about your healthcare if you need them to, and to tell the doctors and healthcare providers what to do for you if you need them to. The document also allows you to give certain instructions. This is called a living will. This is where you are giving specific instructions about what you want done if you are in certain end-of-life situations. So in Maryland, it's broken into 3 main situations. If you are diagnosed with a terminal condition and they do not believe they can do anything to save you, if you are diagnosed as being in a persistent vegetative state and they do not believe that you will wake up, or if you are diagnosed as being in the last stage of life, which is called end stage, and at that point you've lost mental ability and physical ability and it's just a matter of time. The living will portion of the advanced medical directive is where you get to say what you want done in those circumstances. So it's your opportunity to put into writing your instructions in case you're ever in that situation and cannot give instructions at that time. It also allows you to go into more personal detail. I always recommend to clients that they really think about the reality of, if you're ever in a situation where you cannot communicate, are there things that would be important for you to have people know that bring you peace or comfort or that you do not want? So examples of that are, I want to be near a window or taken outside regularly. I don't want to be in a room with the television on all the time. I want to be kept at home as long as possible, even if it uses up every last dime of my money. All of these are instructions that you may know, but that other people may not. And so it's helpful to provide that sort of personal information, either in the advanced directive itself, or I really recommend that people think about writing a separate, more personal, detailed letter where they can go into all of that. The document also allows you to reference whether you wish to be an organ donor, a donor of your entire body to a medical study program, and then it allows you to talk about what you want for your final arrangements: cremation, funeral and burial, any particulars. So the advanced medical directive is the mechanism for you to have some control over who will be making healthcare decisions for you if you can't, and what you want them to do in certain situations, and then additional information that it's important to you that they know. This document does not cover DNR orders, which means do not resuscitate. That's covered in Maryland by a document called the MOLST. This is actually a medical order, and it's something that I recommend that clients discuss with their physician. It's a medical order regarding life-sustaining treatment. That's where the do not resuscitate or definitely do resuscitate information is contained. So talk to your doctor about the MOLST, but also make sure that you have an up-to-date advanced medical directive. The financial aspect of things, when we're talking about protecting against the risk of guardianship and ever having someone else be guardian of our property and money, the documents that we use are the financial power of attorney documents. These are the legal documents where you are giving permission and legal authority to another person of your choosing. This is called your agent. And with both the advanced directive and the financial power of attorney, always include some backup agents. Don't stop at one. What if the one that you name also is incapacitated or has died? Then the document doesn't do you any good. So do always try to include at least 1 to 2 backup agents. Financial power of attorney allows you to designate the agents that you choose to give permission to. And the idea is that they are authorized to step into your shoes and take whatever action they need to for your benefit. It's not for their benefit. They are not allowed to act for their benefit or the benefit of their friends and neighbors and family. They are authorized to take action for your benefit with regard to your money and property and assets. And this is everything from writing checks from your bank account to pay your bills, to making certain investment decisions if need be, to making sure that your real estate is kept in good repair, to signing tax returns on your behalf. If you think about all of the things that you do for yourself with regard to property and money and taxes and assets, the power of attorney is intended to give all of that authority to someone else of your choosing for them to be able to do it on your behalf if need be. We utilize 2 documents in order to make sure that all of the necessary authority is actually provided to the people of your choosing. And those are called the Maryland Statutory Form. And then our secondary one is called a General Durable Financial Power of Attorney. The reason for these 2 documents is because Maryland is an interesting state for many reasons, but one is there is actually a financial power of attorney document that was written into Maryland law. There's a standardized form that was created by the legislature. And in Maryland law, it specifically says, if you use this standardized form and you don't customize it other than changing the names of the people, and a little bit more is allowed, a little bit more customization is allowed. But if you otherwise leave it the way it's written in the law, it's mandatory that financial institutions accept it. So that's incredibly powerful. It guarantees that your financial power of attorney agent can get their foot in the door to be able to act on your behalf. The reality is the document doesn't cover everything. And attorneys who practice in estate planning and elder law know from practice that there are certain powers that do sometimes come up as needed or necessary that are not covered in the Maryland statutory form. And for that reason, we provide clients with a second power of attorney, which is meant to supplement the Maryland statutory form in order to ensure that all of the powers that your power of attorney may need to have to be able to act on your behalf for your benefit. This is our way of making sure they have the full tools in the toolbox available to them to act on your behalf in any way necessary for your benefit. So that's the purpose behind our use of 2 power of attorney documents. After death planning, there are many different options. There are many different options available to people. But the 2 main choices that almost all people rely upon are either a last will and testament or a revocable living trust. A last will and testament is the one that most people have heard of. This is a after death document. This is where I want my stuff to go, and this is the person I want to handle it. The thing that many people don't realize is that a will is only applicable and only effective in probate. So a will does not avoid probate. It tells the probate court where you want your probate estate to go. So using a will does not avoid probate. It is subject to probate. Probate is a court process that involves the court supervising the administration of the estate, and there are certain court timelines, court deadlines, court paperwork that's required, and court costs. So the probate process is something that many people are not interested in having their family or their surviving spouse or whomever it may be handling things after their death. It's something that many people are motivated to avoid. And when that's the case, when someone says to me, well, I'm interested in avoiding probate because I've heard negative things about it, or maybe I had a negative experience with it from a family member's death, or maybe I just don't ever want the court to be involved in any aspect of my affairs, then what we're talking about is utilizing something called a revocable living trust. So the hallmark of the revocable living trust is that it avoids probate. That is its main feature. It does not provide you with asset protection. People often think, I have a trust, therefore I have asset protection. That is not the case always. It depends on what type of trust you have. And there are many different types of trusts. They all serve different purposes, but guess what? They also all come with different cons and negatives and costs. So I said in the beginning, there is no way to have our cake and eat it too. Different types of trusts have different benefits, but they also have different negatives. The purpose of the revocable living trust, the benefit of it is that it will avoid probate at your death. That is why it is used. But the key piece of this is that the avoidance of probate is not totally reliant on the existence of a document called the Revocable Living Trust. The second piece that's more important is making sure all of your assets are properly connected to your revocable trust plan. It is only through that, which is called asset alignment or funding. It is only through that that you are actually setting everything up to avoid probate. So a revocable trust is a piece of paper just like a will. It says where you want your estate to go when you die and who you want to handle it, just like a will. But the difference is that the trust actually owns some of your assets while you're still alive, and it is through that mechanism that it avoids probate at your death. But the key with the revocable living trust is that as long as you are alive, it is revocable by you, and you are the trustee, and it is associated with your social security number. So there's no taking away control from you. There's no adding any sort of tax implication. It is like an alter ego that you still have total control over and you can change at any time, but at your death, it's structured in such a way that it will avoid probate. And that is the end of my quick and dirty overview of the fundamental estate planning documents and considerations. So Jeff, I'll close with that and open to any further questions that may arise.
Well, thank you very much, Olivia. As always, we'll give you a virtual hand for a job well done, as always. And so now, everybody, this would be your time for any burning questions that you might have from that presentation, or any other estate planning questions that you might have for that matter, that would benefit you or the group at large here. So please go ahead and post those. I do have a couple of closing thoughts as we finish up. So again, thank you to Olivia. If you do have a question or want to seek some guidance for yourself, please reach out to Olivia. Her email is right there on the screen, or you can reach out to me at Jeff, Jeff, at elvilleassociates.com, or note it on the post-webinar feedback, and we'll gladly reach out to you to set a time to meet with Olivia. So our Elville webinar series does keep moving along here as we approach the summer. Next Wednesday, we have the Secure Act 1 year later. How will it impact your estate planning and retirement? And that's going to be offered by Steve Elville. Tuesday, June 1st, a new presentation along with the Secure Act presentation, which is also new, protecting and dealing with your digital assets. And that should be really interesting. I know people always think about their digital assets, but we have a lot more digital assets than we think we do. So that should be a very interesting one. That is Tuesday, June 1st with Chuck Bork, who is a business and tax attorney and is a special counsel to Elville and Associates. And on June 15th, we have VA aid and attendance, a tax-free pension for those that qualify, and that's offered by our principal and elder law attorney here, Lindsay Moss. A few follow-up items for today. I'll be sending you the video for today's presentation, and I'll also be sending you a link to our Maryland Elective Share Law article that was written a little while back when that law went into existence a short time ago. Also be on the lookout for our semi-annual newsletter that is going to be coming out either late tomorrow or Monday at the very latest. This is something we're very proud of here at the firm. It is produced entirely in-house, written, designed, edited, everything right here at Elville and Associates. Has a lot of interesting articles and includes a new one about the pending potential tax changes that are potentially on the horizon. And so I hope you enjoy it. You'll all be getting a copy since you're on this webinar. So hope you enjoy it. Let us know what you think about it, and that'll be coming out very soon. So I'll check to see if we have any last questions, and we'll call that a successful webinar, I think. So no other questions. So Olivia, thank you again. Thanks to everybody for attending today, and I hope you have a wonderful rest of the day and a nice weekend ahead. Have a great day. Thank you.
Thank you.